Principal seat matters for admission, item 1 and 2.
Dr. Saraf,
My lord.
you have handed over some document, a note. I have
My-
received it. So, is there anyone from the respondent side?
My lord, only one thing is there, my lord, which I was, lordship must have gone through it, taken the
Actually,
paper.
yes, I've gone through it at that relevant point of time. It has been inadvertently.
Inadvertent.
And even anyway, if it is on the first day, notice has to go.
Notice has to go.
Yes, who is appearing for PP? Who will take notice, Miss Mary or Miss Linda? In item number 4, heard Mr. M. Biswas, learned counsel, appearing for the petitioner. Also heard MS Mary so-and-so, learned APP. Issue notice. How much time, Miss Mary? Item number 4.
My only prayer is that.
You're not getting an interim bail today.
No, my lord, I'm not even praying for an interim bail.
Yes.
This is a regular bail, my lord. My lord, my only prayer is that, my lord, because my case is on a small footing, my lord, if she can take instruction regarding whether 48 has been complied with. On Friday, if they can post it, my lord, only little.
That is for Miss Mary to now tell the court.
Only Friday,
Yes,
handshake.
Friday. Or,
Your Lordship, if the matter can be listed next week.
all right, Monday. Monday is good?
Yes.
Monday. Yes, next.
Okay.
And my lord, I also have a mention to make for a listing tomorrow, my lord, of a matter which I have already filed yesterday. It is regarding, my lord, reduction of the bail amount imposed by the Lanet Trial Court.
What is the system for listing?
Because
Because the senior court is also there, no? There's another court available, so you guys have to make. You mentioned before the appropriate bench. Yes, next.
May I seek your lordship's indulgence in mentioning item 8 of part 2, my lord. I'm appearing on behalf of Mr. Sitlan Tianghima, who is the counsel for respondent to. My lord, if
Item
this
number?
item 8 of part 2.
There are too many lists today. Item 8.
8 of part 2, my
On
lord.
behalf of senior counsel
On behalf of Mr. Sitlan Tianghima.
Lalthiana.
My lord, if this matter may be listed
All right, all
after
right.
we.
Have you informed Mr. Silo?
Yes, my lord.
huh?
We have taken the consent of the other party.
MS
Val Thamwani.
so-and-so, learned counsel appearing for the appellant submits that the leading counsel, Mr. C. Thiangliama, learned senior counsel, is unavailable today due to personal difficulty, and accordingly seeks posting of the matter on another date. There is no prayer is not opposed by Mr. Is not opposed. Repost on such and such date.
18th of June.
Obliged.
Supplementary list for motion, item 5.
Which is the supplementary list? This one.
May I please,
Yes,
Your
Mr.
Lordship?
Victor.
My lord, the petitioner, the dispute hearing is between the petitioner and the respondent number 8 regarding boundary of two villages. Well, the matter is under consideration before the appropriate authority, that is inter-village boundary dispute. Before they come to a settlement decision, my lord, the Kala had proceeded with the relinquishment proceeding of 4-laning of NH06, which was communicated to the petitioner via letter dated 25/3/2026, page number 73.
Page number?
73. Although the dispute between the two villages were under consideration,
Yes.
may I read?
Yes.
With reference to the subject cited above, I would like to
So,
inform you.
despite the competent authority having informed of the dispute,
Yes, my lord.
the matter is being proceeded.
Yes, my lord.
So, that is how you are before this court.
Yes, my lord.
When you are seeking some stay.
Yes, my lord.
Stay of what?
The disputed area, only the disputed area.
Disputed?
Disputed area.
Where is the stay prayer? You are saying stay the process of land acquisition over the disputed area. What is the disputed area?
My lord, at page number 21,
Which number?
21 of my writ petition.
So, I can issue notice and also issue notice on the interim prayer.
Yes, my lord. Yes, my lord.
I'll do
In the
that.
meantime, I'll take steps.
You take steps. Heard Mr. Victor L. Alte, Learned Counsel, appearing for the petitioner. Also heard M.S. Vani, Learned Counsel, appearing for respondent numbers.
1 to 5.
State Counsel, 1 to 5. Mr. Lalshyama, you are also there in this case? 1 to 5. Anybody there for Kala? Generally, notice goes?
Notice may go,
Notice
my lord.
goes. And what about NHCL and NHIDCL?
Notice may go.
Issue notice by way of this petition under Article 226 of the Constitution of India. The petitioner is assailing the impugned minute Meeting minute dated 11/8/2025, on the ground that despite objection having been raised by the petitioner as regards the boundary between Sipir and Sairang Dintar, the said meeting proceeded. Issue notice making it returnable on such and such. MS Vani accepts notice for 125. Remaining steps repost on such and such dates.
25-6.
Notice on the interim may be made.
A notice on the interim as well.
Deeply obliged.
Jailer list, item 1 for admission.
What is this, Mr. Joseph?
Is that university registrar case?
Oh, yes. How come? Oh, this has come for admissions.
Admission. So, my lord, the endeavor is supposed to be made for disposal at the admission stage, my lord. So, my lord, in this case, as I had mentioned before, my lord, we are challenging the appointment of the respondent number 5 to the registrar post, my lord. And we have two basic arguments in this case, my lord. As I take your lordship through the facts, my lord, I will touch on these two submissions. Our first submission, my lord, is mainly that the respondent number 6 appointment, my lord, is illegal simply because it is against Article 21. It is biased. That is our first argument, my lord. Because because of the principle, my lord, that no one can be a judge of his own cause.
Article 14.
Article 14 and 21, basically, my lord. That's our first submission. And our second submission, my lord, is that he has overstayed his deputation, my lord. So there are these two arguments. And, my lord, I will take your lordship through the facts. Okay, I'll take your lordship through the relevant facts, my lord. And the first important page, my lord, I'll take your lordship to is at page number 46, my lord. This is from the Mizoram University Act 2000, my lord.
46.
I'll take your lordship through some of the provisions, my lord, that are relevant for the post of a registrar. (46) towards the end, my lord, your lordship will see the registrar. This is section number 14(1), my lord. The registrar shall be appointed in such manner as may be prescribed by the statutes. The registrar shall have the power to enter into agreement, sign documents, and authenticate records on behalf of the university, and shall exercise such powers and perform such duties as may be prescribed by the statutes. Now, my lord, we will have to go.
Sorry, this is your reading 14.1, right?
14.1 and 14.2, my lord.
14.1 says registrar shall be appointed in such manner as may be prescribed by
That is
statute.
statutes.
The registrar shall have the power to enter into agreements, sign documents, and authenticate records on behalf of university and so and so. Now, we are concerned with the appointment of a registrar.
Registrar.
And that is given. That is there any rules,
So that is
guidelines?
provided in the statutes. Okay, sorry, my lord, I'll take your lordship to the statute, my lord, at page number 62. This is the relevant portion.
62.
Page number 62, my lord, this is part of the statutes. Registrar, the clause on registrar, my lord, is at rule number 4.
Yes.
It
Yes.
says like this, my lord. The registrar shall be appointed by the executive council on the recommendation of a selection committee constituted for the purpose and shall be a whole-time salaried officer of the university. 2. He shall be appointed for a term of 5 years and shall be eligible for reappointment. 3. The emoluments and other terms and conditions of service of the registrar shall be such as may be prescribed by the executive council from time to time and accordingly provided in the ordinances, provided that the registrar shall retire on attaining the age of 62 years, provided further that the registrar shall, notwithstanding his attaining the age of 62 years, continue in office until his successor is appointed and enter upon his office or until the expiry of a period of 1 year, whichever is earlier. Now, this clause number 4 is particularly going to be important, my lord. When the office of the registrar is vacant, or when the registrar is by reason of illness, my lord, absence, or any other cause, unable to perform the duties of his office, the duties of the officer shall be performed by such person as the vice chancellor may appoint for the purpose. Now, the reason why I'm stressing this particular provision, my lord, I'll read again, my lord. When the office of the registrar is vacant, or when the registrar is by reason of illness, absence, or any other cause, my lord, this is important, any other cause, unable to perform the duties of his office, the duties of the officer shall be performed by such person as the Vice Chancellor may appoint for the purpose. The reason I am stressing on this point, my lord, is because of our first submission. The registrar, the respondent number 6, my lord, all throughout the appointment, my lord, he was operating and functioning as the registrar. And I'm saying, my lord, this rule 14 is important because
All
of
along,
any other cause.
R4.
Yes, R4 is very important for this
R,
purpose.
no, what did you say? What were
When
you
the office
emphasizing?
of the registrar is vacant, my lord,
Yes,
or when the registrar is by reason of illness,
yes,
absence,
yes.
or any other cause, unable to perform the duties of his office.
Yes.
The duties of the officer shall be performed by such person as the Vice Chancellor may appoint for the purpose.
So
My lord,
who has been who is discharging this work right now?
this work is discharged by the respondent number 6,
R6.
R6, even at the time when he was being considered for appointment. So lordship will become
And
relevant.
who are you?
My lord, we were also participants. Our names, I'll show your lordship, the names that
So you are one of the contending
we are one.
contender to that post.
Correct, my lord. Both of
And
us.
the person now that has been selected is R6, who was anyway discharging this the job of the registrar upon that post falling vacant. Upon the post falling vacant.
Correct. He was the previous registrar, and when the post became vacant, my lord,
Oh, it got extended.
it got extended, and then.
So
when-
he was the previous registrar.
Correct, my lord. That is the case. Now, my lord, I'll not read 5 because 5 is not very relevant for us, but I'll come to 7, my lord. The
Who is
registrar
appearing for R6?
R6, my lord.
Mr. Malhotra.
Yes.
You are the one who's creating the trouble. You're not going. You retired, right? And Mr. Lian Shrima is for the university.
Yes, my lord.
1 to 5.
University, Mr. Joseph is respondent numbers?
1 to 5, my lord.
1 to 5.
Yes.
Now, number 7, my lord.
Yes.
The registrar shall be ex officio secretary of the Executive Council, the Academic Council, and the College Development Council, but shall not be deemed to be a member of any of these authorities, and shall be ex officio member secretary of the court. Now, my lord, my humble understanding of ex officio secretary means a person who becomes a secretary by virtue of holding another office or post. Because he's a registrar, my lord, he's functioning as a secretary. That is how I understand ex officio, my lord, secretary. Now, my lord, come to the next page, my lord. At page number 63, my lord will see 8, the duties of the registrar. And this will become more relevant, my lord, after a point. Now, it says like this. It shall be the duty of the registrar, A, to be the custodian of records, the common seal, and such other property of the universities as the Executive Council shall commit to his charges. Now, my lord, he was operating as the custodian of records during the entire recruitment process. Now, B, to issue all notices, convening meetings of the court, the Executive Council, the Academic Council, the College Development Council, and of any committees appointed by these authorities. To keep the minutes of all the meetings of the court, the Executive Council, the Academic Council, the College Development Council, and of any committees appointed by these authorities. To conduct the official correspondence of the court, the Executive Council, the Academic Council, and the College Development Council. C. To arrange for and superintend the examinations of the university in accordance with the manner prescribed by the ordinances. F. To supply to the visitor copies of the agenda of the meetings of the authorities of the university as soon as they are issued, and the minutes of such meetings. To represent the university in suits or proceedings by or against the university, sign powers of attorney and verify pleadings or depute his representative for the purpose. And H, to perform such other duties as may be specified in the statutes, the ordinances, or the regulations, or as may be required from time to time by the Executive Council or the Vice Chancellor. Now, my lord, with these things in mind, my lord, let me take your lordship to another page, my lord. That's page number 73. Page number 73, my lord. Clause number 18, 1A. there shall be a selection committee for making recommendations to the Executive Council for appointment to the post of professor, reader, lecturer, registrar, so and so. So, my lord, I'll read till registrar only. So, my lord, with these provisions in mind, my lord, I will take your lordship to the advertisement.
But it's not your case that he is not competent. Is that your case?
That he was?
That he is not competent to man the post?
No, my lord.
Because there is now a regular selection.
There is a regular selection.
Again, he has come through the regular selection,
He has come through the regular selection.
isn't it?
Correct. My lord, my first submission.
Is one of your submission that he is not competent?
My lord, my first submission is, my lord, that he was he was operating as the registrar, and the duties of the registrar I have already read, my lord. First is he was the custodian of records during the entire recruitment process. Second, he was a secretary to the Executive Council. Now the Executive Council, my lord, makes the final decision with respect to the appointment. He was in attendance.
Okay. So, in other words, you are saying because he was already manning that post pursuant to his retirement, also discharging.
Yes.
So, those things are admitted facts.
Admitted facts.
That after retirement, it was a retiring or after tenure.
After his tenure had come to an end,
basically
yes.
tenure. So after the tenure, that R6 was only looking after the post of the registrar. That's an
Correct.
admitted fact.
That's an admitted fact. In fact, my lord, if you
Take me back to that post. That yes, the registrar shall be ex officio secretary of the
my lord,
Executive
number
Council.
7, page number 62.
Yes, I've got it. And the selection is done by the Executive Council.
Final decision is made by the
So
Executive Council.
basically, you are saying that he himself is. No one can be the judge of his own cause.
Yes,
you are
you-
trying to bring that.
Correct.
Here.
I'm trying to-
Correct.
yes.
That is
My-
how you are trying to attract bias.
Correct, my lord.
Correct.
Yes, my lord, that's true. And my lord, because I have already read Rule 4 as well, my lord, at page
Yes.
62.
Yes.
Now, it is not a situation where the registrar has to be, my lord, functioning in that capacity. Because if I read Rule 4 again, my lord, it says
And
like
it,
this.
yes, it says the duties of the officer shall be performed by such person
Yes,
as the VC may appoint for the purpose.
yes. And it says here, my lord, or, my lord, these provisions, or any other cause, because this is such an inclusive term.
Where is or?
My lord, when the office of the registrar is vacant, or when the registrar is by reason of illness, absence, or any other cause,
Unable to perform.
correct,
office
unable to perform his duties. Now,
But in our case, it is because it fall vacant because the tenure expired.
my lord, yes. Firstly, it fell vacant, but it was extended, my lord. This is
So
admitted
that's right. Because it fell vacant, it got extended. That extension must be under this only, under Rule 4 only.
under Rule 4.
I'm just trying to understand the admitted facts.
Correct.
So now because he himself got extended.
Correct.
Yes, it could have been someone else also.
It could have been someone
could
else.
have been, but-
even if he was extended.
There is no problem. That you're not challenging. But the fact that he got extended, at the end of the day, he's member of that executive council,
Correct.
which took the final decision of the selection of the candidates.
Correct.
And in that that executive committee of which he is also a member selected the R6 itself.
Selected him. And my lord, that's not it, my lord. I will take your lordship through the records. He was in a position to tinker with the executive decision as well, my lord. He was writing the
He
agenda.
is part of it. He is one of it.
Attendance.
Going, I don't know. Mr. Malhotra is giving me a smile from that side. I am yet to hear the other side.
Yes.
But the way you are projecting your case, it appears he's part and parcel of
He's
the
part and
executive
parcel.
council.
It's true.
So where is that tinkering necessary? His whole presence in that
itself.
executive council vitiates the whole fairness.
Correct.
Right?
That's the first. Mere presence, my lord. Your lordship has rightly
His
pointed.
presence therein
And my lord,
vitiates
it does not stop there. This is what
because
I'm
the
trying to say.
entire concept of fairness gets
Yes.
defeated.
Correct.
That's how I'm looking at it. Unless the other side has
Argue.
some looking by their looks, it seems they have a lot of bullets hidden under the sleeves.
Yes.
Huh? They're going to pull them out now.
And my lord,
Yes.
I'll take your lordship to the employment notice, my lord. This is at page number 142.
Page number
142, my lord.
142.
2, my lord.
Yes.
This is the employment notice dated 18 June 2024.
Yes.
And my lord will see number 4 in the box. This is the registrar.
Yes.
And your lordship will come to page number 153. This is still part of the employment notice, my lord.
150.
153.
Yes.
Now, this is with respect to some of the rules regarding the registrar.
Yes.
I mean, the conditions regarding the registrar. I'll not take your lordship through all of that, my lord. And
Tenure
then-
is 5 years.
Tenure is 5 years, preferably below 53 years. Retirement age 62 years.
Yes.
Now, after this employment notice was issued, my lord, the applicant, the petitioners, as well as the respondent number 5, if your lordship will come to page number 166, sorry, not 166. Okay, I'll take your lordship to 167.
167.
Yes, the petitioners, as well as the respondent number 6, they applied and they were shortlisted, my lord. They were
That advertisement is part of the records.
part of the records.
Can you give me that page as well?
Page number 142, my lord.
142.
42. And then the relevant part regarding the registrar is at page 153.
Okay, 142 I have already seen.
Yes,
Oh, this is the employment notice.
This is the
Sorry.
employment notice.
Sorry. And now 167.
167, my lord.
You are at serial number 4
I am at serial number 5 and serial number 10.
and serial number 2 petitioners.
2 petitioners.
And 4 is the R6.
Correct, my lord. And these are the valid list of applicants for
But there are others also above. 1, 2, and 3.
others have not come forward, my lord. So the 2 of them are seriously aggrieved by this. So that's why they have come and filed this writ petition, my lord.
This is merit list or what?
This is a valid list.
Valid list.
Yes.
So this matter came at this stage.
No, so this, I'll take your lordship to the next one, my lord, at page
Yes.
168.
I'm sorry, I might be going little faster. You
So
take
it's
your
absolutely
pace,
fine, my lord. It's absolutely
Yes.
fine. My lord, this is the first email sent by the respondent number 6, R6. Now, this is, my lord, if your lordship will see, date is given 10th October. Your lordship has seen it?
Yes.
10th, it's underlined.
Yes,
10th
I've
October
seen it.
2024. Nomination of external experts for selection of registrar and internal audit officer.
Yes.
My lord, he is the one sending this email.
Who,
Because,
where do I get him?
my lord, on the top, your lordship has seen
Yes,
Professor
Professor
Lalundanga,
Lalundanga.
Professor Lundanga, registrar at MZU.
Yes, yes.
It says like this, my lord, this first email, Sir, Madam, this was sent to the Executive Council. The selection committee for the post of Registrar and Internal Audit Officer, Mizoram University, scheduled to be held on 23rd April 2024. For this, the Vice Chancellor Mizoram University has nominated the following as external experts. My lord, he was privy to the external experts before his interview. The first is Professor G.D. Sharma, Vice Chancellor, University of Science and Technology, Meghalaya. Second is Professor Alok Burha Gohain, former Vice Chancellor, Dibrugarh University. Third is Professor S. Sundar, Director, National Institute of Technology, NIT, Mizoram. Now, this was then approved. My lord, we'll see at page number 169.
Yes.
Here it says, requested that comments, if any, be submitted to him, my lord, to the registrar via email. And his email, my lord, is given registrar. Latest by 17th October 2024.
Yes.
So this was the first. And then, my lord, the second one at page 170.
Yes.
This is now the meeting minute. It says like this: minutes of the emergent meeting of the Executive Council through e-circulation 10
Signed by himself.
signed by himself again.
Yes.
And thereafter, my lord, the recruitment process continued.
So that then these 3 got finalized as
These 3 got finalized.
external experts.
External experts.
Right.
Then
Yes.
the recruitment happened, my lord.
Yes.
And then after the recruitment, after this recommendation was made, sorry, my lord, after recommendation was made by the selection committee, this letter was sent by him, my lord. This was the meeting, draft meeting minute, 11th November 2024. Your lordship has seen
Yes,
below his
signed
name is
by
there.
him,
And
R6.
my lord, the second paragraph is quite significant, my lord.
Comments, if any, may be submitted to the undersigned.
Yes. On or before 13th November 2024.
So this is the draft minutes of the 66th meeting of the Executive Council. What does this? What is this Executive Council meeting?
My lord, I'll take your lordship to page 172. This is the meeting.
17?
2.
Yes.
Now, my lord, we'll see the meeting minute, members present in the
So
bottom.
this is the selection committee meeting.
This is the meeting that considered the recommendation of the selection committee, my lord.
Okay. So this is the final.
Final.
The seal that seal the.
Seal, yes, that had- that
the
considered-
selections
correct,
made by
correct.
the experts.
Yes.
Selection was by the experts, right?
Expert, they made the recommendation. I had read Lordship at that time. Recommendation is recommendation, my lord.
See, not only that, those 3 experts were appointed by the R6.
R6. Through his email, he was privy to it. My lord, at serial number 12, that's him. He was in attendance. And I'll read this, my lord, because this
Yes,
draft.
please. Yes, please.
This draft is very important. The
Yes,
chairman welcomed the members attending the executive council meeting and introduced Professor H.K. Laldin Pui Fente, Department of Psychology, Mizoram University, being a new member attending the meeting for the first time. The chairman informed the members that the emergent meeting has been convened due to the urgent need for approval of the minute of the selection committee for selection of registrar and internal audit officer, Mizoram University. Thereafter, agenda items were taken up for consideration with the approval of the chair, and the following resolutions were adopted. Next page, my lord, at page number 173. Items for consideration, EC 6631, my lord.
Yes.
It says like this: Mizoram University has advertised floated employment notice vide number so and so for the post of registrar, and the selection committee for the said post was held on 23rd October 2024. Recommendation minutes of the selection committee is placed with the chairman in a sealed envelope. The Executive Council resolved to approve recommendation of the selection committee for registrar Mizoram University selecting Professor Nulal Nundanga, that's him, Department of Forestry, Mizoram University, for the said post. The council, this is very, very significant, this last part, my lord. The council further resolved that this appointment shall take effect from 1st April 2024, in line with clause 20 of the Mizoram University statute, since Professor Nundanga has previously served as registrar till 30th April 2024 and is currently continuing to hold the post of the registrar until new appointment is made or until further order, whichever is earlier. Now, this was the draft meeting minute, and the final meeting minute is the next page, my lord, and it's at page 174. But the relevant one, my lord, is at page number 176. The relevant portion of the agenda, my lord, of the decision is at page 176. Now, my lord, at page 176, it says like this. I'll read the second part only, my lord. 6631. I'll read the second part. The Executive Council resolved to approve recommendation of the selection committee for registrar, Mizoram University, selecting Professor Lalundanga, Department of Forestry, Mizoram University, for the post of registrar, Mizoram University. This was the final. And, my lord, what I want to point out at this stage is, my lord, he was not only in attendance, he was not only writing the meeting minutes, my lord, he was in a position to tinker with the meeting minute itself, my lord. The reason I say this is, my lord, because if your lordship has seen the draft, in the draft, the third paragraph was there, my lord, where he was given, where he had written, my lord, that he should be retrospectively appointed. Now, of course, the EC stepped in and said that that last paragraph has to be deleted, and finally it got deleted. But what I want to point out, my lord, his involvement in the entire process, my lord, cannot be denied. This is the point I want to make, my lord.
That is your main,
Yes.
main challenge.
Absolutely, my lord.
How can he be there?
Yes,
He should not have associated himself. He could have always withdrawn himself.
definitely.
He
Especially
did
because
not do that.
yes,
Right from the beginning to the end, he was there.
yes,
At least the document says, I mean, these documents can't be disputed.
yes,
These are part of records. He signed it.
yes,
Have they? There's no dispute to the signatures. There's no dispute to the presence of the respondent number 6
yes,
in that selection committee in that meeting at
Yes.
serial number 12,
correct.
whereby at the end, whereby the recommendation of the selection committee appointing so and so as the registrar was affirmed.
Yes.
He was also part of that.
Absolutely correct. And this is not a situation, my lord, where the provisions, the statute, does not provide a way out. My lord, there's a clear provision that says when he is not in a position to function, that it's in fact, my lord, if your lordship.
What happens if suppose if suppose the post of registrar has fallen vacant, right?
Yes,
Now suppose in a given, because there is also no bar for the same person to be considered again for the post or for an extension, and
Yes.
he's been given his extension. Now, suppose a fresh selection is to be taken.
Yes.
Then suppose the registrar now, because if he wants to contend, what can be done in that situation?
My lord, page number 62, section 4.4 would come in, my lord.
60?
62. Rule number 4, subclause 4 would come in.
Yes.
My lord says, I read before, when the office of the registrar is vacant, or when the registrar is, by reason of illness, absence, or any other cause, unable to perform the duties of his office. My lord, that would be a
So basically, because of the fact that now he's contending for this post, he shall not be in a position to perform his the duties of his office.
Correct.
Therefore, the VC should have stepped in
Yes.
and appoint someone else for the purpose.
Absolutely.
This
my
is
lord.
what you're saying,
This
right?
is the point I want to make. And my lord, it's not an option given to to vice chancellor, my lord. Because if your lordship will continue reading, it says like this: the duties of the officer shall, my lord, the uses of the word shall be performed by such person as the vice chancellor may appoint for the purpose. So any other person, my lord, who is competent can be appointed for this particular purpose. My lord has seen the last page, the second last line, officer shall, my lord. This is a mandatory,
Officer?
shall be performed by such person as the vice chancellor may appoint for the purpose.
Where did you read that from?
My lord, your lordship has seen like the duties of any other cause unable to perform the duties of his office. Lordship has seen
Yes,
that.
the duties
These
of
of the officer shall,
Okay,
yes.
okay. All right.
And finally, my lord, he was appointed to the post of the registrar. If your lordship will come back to page number 179,
That's the impugned order.
that's the impugned order. It says the selection committee, and my lord, I want to read this out also, my lord. 179.
Yes. Yes, yes.
It says like this: on the recommendation of the selection committee and
with
the approval of the 66 Executive Council.
Executive Council.
Yes, this was
of
where
which
he was in
is
attendance.
part of it.
Correct, my lord. My lord, I need not go into long precedents, but I would like to cite one judgment,
Yes,
my lord.
please. Yes, please.
My lord, this was in Pramod Kumar Bajaj versus Union
Give,
of
give.
India. I have given the citation, my lord, printed copy. This was from Manu Patra, since I printed out, my lord. The citation is 2026 INSC 101.
This is a decision of the apex court.
Apex Court, my lord. And if your lordship will come to page 11, the law with respect to bias has been explained by the Supreme Court, my lord.
Yes, please.
Page number 11, paragraph number
Where are
42.
the page numbers?
My lord, page number is in the bottom, beside the
Right,
date
right.
in
I've got
brackets.
it, I've got it,
Yes,
I've got
page 11 of 15. Paragraph number 42. Reference. Lordship has seen that?
Yes.
Reference in this regard may usefully be made to the observation of this court in state of Gujarat versus R.A. Mehta on the doctrine of bias, which encapsulates the principles governing the present controversy. The relevant observations made by this court in the said judgment are reproduced herein below. 58. Absence of bias can be defined as the total absence of any preconceived notions in the mind of the authority judge, and in the absence of such a situation, it is impossible to expect a fair trial, and no one would therefore see any point in participating in one, as it would serve no purpose. The judge authority must be able to think dispassionately and submerge any private feelings and respect to each aspect of the case. The apprehension of bias must be reasonable, that is, which a reasonable person would be likely to entertain. Bias is one of the limbs of natural justice. The doctrine of bias emerges from the legal maxim nemo debet esse judex in propria causa. It applies only when the interest attributed to an individual is such so as to tempt him to make a decision in favor of or to further his own cause. There may not be a case of actual bias or an apprehension to the effect that the matter most certainly will not be decided or dealt with impartially, but where the circumstances are such so as to create a reasonable apprehension in the minds of others that there is a likelihood of bias, my lord, this is important, affecting the decision, the same is sufficient to invoke the doctrine of bias. 59. In the event that actual proof of prejudice is available, the same will naturally make the case of a party much stronger. But the availability of such proof is not a necessary precondition. For what is relevant is actually the reasonableness of the apprehension in this regard in the mind of such party. In case such apprehension exists, the trial, judgment, order, etc. would stand vitiated for want of impartiality, and such judgment order becomes a nullity. The trial becomes coram non judice. 60. While deciding upon such an issue, the court must examine the facts and circumstances of the case and examine the matter from the viewpoint of the people at large. The question as regards whether or not a real likelihood of bias exists must be determined on the basis of probabilities that are inferred from the circumstances of the case by the court objectively, or upon the basis of the impression that may reasonably be left upon the minds of those aggrieved or the public at large. The aforesaid observations made by this court makes it clear that an authority exercising adjudicatory or selection functions, in our case it would be selection functions, must not only act fairly but must also appear to act fairly. For justice must manifestly be seen to be done. The rule against bias would certainly be attracted where the person authority intrinsically involved in the evaluation process has a personal connection with, personal interest in, or prior involvement in the matter under consideration, or has earlier taken a position which he may be interested in sustaining. The doctrine is applied not only to avoid the possibility of a partial decision, but also to preserve public confidence in the impartiality of the decision-making process. We may also gainfully refer to the judgment of the High Court of Judicature at Allahabad in K.M. Shailja Srivastava versus Banaras Hindu University, wherein the following observations were made. The allegations of the petitioners are that the proceedings before the Examination Grievance Board as well as Central Grievance Board are both vitiated. Before dealing with the allegations regarding the Examination Grievance Board, I may first mention that the proceedings before the Central Grievance Board were vitiated because of the presence. My lord, I will not go into all of these. It's all there. But my lord, finally, the Supreme Court's conclusion, my lord, at page number 13, at paragraph number, your lordship has seen it.
You read it if you want.
My lord, I'll read for my satisfaction.
Yes, please.
At page number 14, it says like this. 1. It is not necessary to establish actual bias. A reasonable apprehension or likelihood of bias is sufficient to vitiate the proceedings. As stated by Garner in his administrative law, turning our attention to the substance of the rule relating to bias, the first point to emphasize is that it is not necessary to prove actual bias. The natural justice bias rule looks to external appearances rather than the proof of actual improper exercise of power. In this connection, Geoffrey Flick in his book Natural Justice has mentioned there are two established lines of authority, one to the effect that an interest will disqualify if it gives rise to a real likelihood of bias, the other to the effect that all that is needed is a reasonable suspicion of bias. It is the reasonable suspicion test which currently seems to hold sway. My lord, in our case, my submission is there is reasonable suspicion. It may also be pointed out here that in the case of Kirti Deshmankar Supra, the Honorable Supreme Court has used the words reasonable likelihood of bias and not real likelihood of bias. This distinction between real likelihood and reasonable likelihood is important. And in my opinion, even if there is no real likelihood of bias, a reasonable likelihood from the point of view of the petitioners will vitiate the proceedings. In G. Sarana's case, the test laid down was whether there is a substantial possibility of bias animating the mind of the member against the aggrieved party. Even if one member of the selection committee suffers from the disqualification of the rule of bias, then the entire selection or proceeding is vitiated because it is not possible to know as to what extent such disqualified member influenced the others. Where a person is disqualified due to rule of bias, he should disassociate himself from the proceedings, my lord. For bias is in a member of a recommendatory body will also vitiate the proceeding.
It fell from the court.
Yes.
He could have disassociated himself.
Correct.
The VC could have appointed anyone.
Yes.
They could have done it.
It's just like, my lord, it's say in court.
Because justice is not what justice is
Just not-
done. Justice is what justice. It has to be seen to be done.
Yes. My lord, it's the
Here,
same.
the very fact,
It's a very fact.
he may be a saint,
Yes.
but the very fact that he is part of it
Yes.
has tainted it.
Correct. My lord, in courts, we know, my lord, this is happening all the time. Lordships recuse them yourselves. That simple thing has to be done by him, my lord. He had not
And
done
there
it.
is a provision allows.
Rule 4.
He could have just stepped, since he is himself contending.
Correct.
What is their stand in their affidavits? Have they disputed any of these positions, the factual positions?
My lord, they can correct me. Their basic stand, my lord, was that he he was not, when his name was considered, when that agenda was considered, he walked out of the room. He was not in attendance. Humble submission, A.K. Krepak, in A.K. Krepak, same line was taken, my lord.
That is part of this.
My lord, I have
AK
given the
Kripak is
citation. I have-
1.6 paragraph.
Yes, 1.6, and I have given the citation also in A.K. Krepak, my lord.
Here also it was that walking out.
Of course, my lord. If your lordship will come to, if your lordship will come to page 267,
Yes.
paragraph 9,
267.
267 of the
Yes.
paragraph 9. Nakhish Bunt, this is the person concerned in that particular case.
Yes.
Nakhish Bunt was also one of the candidates seeking to be selected to the All India Forest Service. We are told that we take it to be correct that he did not sit in the selection board at the time his name was considered. My lord, the same defense was taken by my learned friends for selection, but admittedly he did sit in the board and participated in its deliberations when the name of Basu, Baik and Paul, his rivals, were considered for selection. It is further admitted that he did not participate in the deliberation of the board while preparing the list of selected candidates in order of preference.
No, but here he himself selected those 3 panelists, the experts.
Yes, he sent the email.
He had selected it. He sent the correspondence. It was to him. The objections came. Then he finalized it.
Correct.
And at every stage he has participated.
At every stage. And finally, my lord, that meeting minute also, he had to...
And whether he's walked out or not,
Yes.
maybe even if he has walked out, his presence is very much there.
Yes.
He was part when that 66, right?
Yes, 66
Executive meeting took place
Yes.
for affirming the recommendation. He
Yes.
was part of it. He was at serial number 12, correct?
Correct. And in
Anything
ac-
more?
No, my lord.
I've heard you enough. I've given you
Eh,
1 hour.
Yes, my lord. I will not do the deputation now because I think lordship will stick to this for now.
I
Deputation.
don't know. Yeah, yes, you can leave that for the while till for your reply. You will have a right to reply.
I'll have a right to reply, my lord. I can leave.
What deputation?
My lord, the other issue we have is, my lord, he has overstayed his deputy because, my lord, the
Anyway,
first question.
let's not get into that because
for now.
right now there is already a regular selection
Yes,
and he's already been selected in his regular selection.
but then, my lord, that selection itself would become illegal simply because he was on deputation.
Suppose this,
My lord, the first question with respect to deputation, I had asked myself, my lord, was
Yes, sir.
since he was already serving in the Mizoram University in the forestry department. Now his appointment, my lord, to the post of a registrar, which is also in the Mizoram University, my lord, this is the question I asked myself at first, whether that would be a deputation. Because usually when we say deputation, my lord, from one other department like PWD, he will go to education, something on those lines, my lord, deputation. But this is a situation where he had from forest department to the registry post. So the question I asked myself at first was whether this is a deputation. But, my lord,
was he not?
the university themselves has
Mr.
admitted.
Joseph, you have slightly confused me right now.
Yes.
I was going ahead with the premise that this R6 was
Yes.
the registrar of the university. His 5 years having been expired, that was again extended.
Correct. So, my lord, for the
That much is correct?
That is correct.
So initially when he was brought in,
Yes.
he was brought by way of a deputation.
That is what happened.
In his initial term.
Initial term.
But that you have never challenged.
No, so the second term also, my lord, is actually
An extension.
Deputation, because they have mentioned like that. The university themselves has mentioned like that.
Right now the challenge is to the new appointment, right? At page 179. That's your challenge.
The reason I challenged that.
179 is under challenge, correct?
Yes.
Now 179 has nothing to do with his previous term, deputation and all that. There was an advertisement. Pursuant to that advertisement, he has applied and he has secured the appointment, which is at 179. Correct?
Correct.
So this is not some deputation.
Let me clarify.
I'm just, you respond yes or no. First you respond yes or no.
This is a deputation. The reason I'll explain.
Why? How can it be a
Yes.
deputation?
My lord, I'll explain. This is the reason why, my lord, that question that I had posed myself initially. Let me just take your lordship to the history of the respondent R6, my lord. Initially, he entered the Mizoram University.
I'm telling you, I was almost in your favor. Now you have confused me. Now I might just keep this matter because I was thinking,
Lord, I will stop
I can see a lot of tiring faces in the back waiting for their matters to be called up. Huh?
My lord, I'll stop the deputation
Since
sufficient
we
for-
had a single bench in the morning, the division bench in the morning, this bench could only sit in the second half, and yours being the first matter, I see a lot of, they're very, they're giving me those looks, and I'm feeling guilty now. I'm telling you.
No,
Huh?
my lord, with the issue regarding deputation, my lord, if it becomes necessary, my lord, during the reply, I will.
All
go
right.
to that
Yes,
point.
Mr. Lal Sharma. You see, I am only on one thing. I find that the primary contention of the petitioner is that the respondent number 6, himself being the registrar, being a member of the executive council, he has not only participated in the selection process which which approved the recommendation, he was also the one who appointed those experts. He communicated with them. He gave the approval seal to their appointments. Then ultimately, when the recommendation came, he was part and parcel of that 66 minutes. His name appears at serial number 12, and the executive council approved it, appointed it. So now the onus lies on you to show that no, that R6 have disassociated himself, that he has never done it. If you can convince that by showing some materials, of course you may have a case. But if you cannot, then this case, on the face of it, you see, arbitrariness is writ large.
My lord.
How can he participate in his own selection? Because you see, I'm taking it like that. I'm taking it very simply.
True, my lord.
Admittedly,
coming to
he
that, my lord-
participated. Admittedly, he appeared in that. He applied for the post. He appeared before the selection committee.
My lord.
Correct. His name
my
was recommended by that selection committee,
My lord.
and the executive council, which actually approved it, is none other but a committee where he himself is one of the member.
Right, my lord. But at the same time, my lord, before coming to those points, I would like to submit to your lordship that we have filed affidavit in opposition.
Yes, sir.
I'm for respondent number 1 to 5. I have challenged the maintainability of the present writ petition. Although the petitioners have challenged the appointment of the respondent number 6 to the post of registrar, Mizoram University, without challenging the recommendation of the selection committee, which was held on 23/10/2024, made in his behalf. And besides this, the petitioners decided to take part in the selection process for appointment to the post of registrar, Mizoram University, without raising any objection against the nomination of the 3 external experts by the Vice Chancellor, my lord. Hence, the petitioners cannot be permitted to challenge the appointment of the respondent number 6.
Your second point finds weight with the weight in the minds of the court.
My lord.
At the same time, can a writ court ignore an illegality which appears to be writ large again? I'm asking you this question.
Oh, yes, my lord. At the same time,
the writ court is wide enough to reach wherever there is illegality. Yes
My-
or no?
my
There are no
affidavit
technical-
can be
there are no
perused.
shackles to the power of a writ court. No,
True, my lord.
it is apparently manifestly demonstrated on record that you have. I'm sorry, not you. Respondent number 6, Mr.
My lord.
Malhotra's client, is very much involved in the whole selection.
On
and
record-
selecting whom? Himself. This is how it is appearing from the records. These are not something coming out from the court. These are your records, the
We have-
university records, which you are not disputing.
we have somehow-
You are not disputing. You are questioning the maintainability of a writ petition. Correct? No, he may not have challenged the recommendation. That argument of yours will, I'm sorry, I'm not going to accept. Second, you have a point that he never objected, he participated.
right, my lord.
You may have. After seeing I don't know, I might say that I may agree with you, I may disagree with you. But I'm saying, even if I agree with you, even in that situation, can this court close its eyes to the illegality that is manifestly apparent on the face of the record while exercising a writ jurisdiction.
That is true. At the same time, my lord, my submission is to be considered at the same time.
Of course, why not?
If it is, if the instant writ petition is not maintainable, then they will have to file afresh.
Very well. And anything
But-
more?
And-
That's all? Anything more?
My lord, apart from that, I am having some citation in this
Yes,
connection.
yes, please.
Amarjit Singh and others versus Devi Ratan and others, reported in 2010, Volume 1, SCC, page 417,
Can you take it down?
para 28.
Para?
Para 28, page 426, my lord.
Yes.
I'm reading with lordship permission.
Yes.
In the instant case, promotions had been made by two different DPCs held on 19/12/1998 and 22/1/1999. Both DPCs had made promotion under different rules on different criterion, and their promotions had been made with retrospective effect with different dates notionally. In the instant petition, in the writ petition before the High Court, the promotion of the appellants had not been under challenge. The seniority which is consequential to the promotions could not be challenged without challenging the promotions. Challenging the consequential order without challenging the basic order is not permissible. My lord, this is in my support to my submission against the maintainability of the present writ petition, my lord. Since the petitioners have failed to...
What do you want to rely from para 28?
Para 28, my lord.
No, which paragraph did you just rely?
Para 28.
Correct. For what? How does it? Because here the promotion itself was not under challenge. Then
Challenging-
obviously the
My lord.
consequential seniority, how can it be
The
interfered?
principle laid down by the apex court
What
in
is
the
the
present
principle?
case, challenging the consequential order
Yes, but
without
Mr.
challenging the basic
but,
order is not
Mr.
permissible.
Rajshama, you have to understand
My lord.
that what is challenged before this court is the final appointment of the respondent number 6.
Yes, without challenging the...
No, because the
recommendation
you
of the selection committee, my lord.
The recommendation is not essentially required to be challenged by him. The recommendation.
My submission to your lordship is-
The recommendation is ultimately accepted by the registrar. Now, it is not necessary that in all cases the recommendation has to be accepted.
That
by
is
the,
true.
Correct. So this was there was a discretion.
My submission-
Now there are two ways to see this matter. You see,
My lord.
there could have been one way, send it back to that stage where R6 will have to disassociate himself completely. You can appoint someone else to that post, and everything starts from beginning. That is the only outcome.
My lord.
Then these are not consequential orders. This is very what is challenged is the main order, the order. Now you see in all those selection committees, there are so many selection minutes. Ultimately, the departmental committees accept it. Now, the acceptance and the final orders are always under challenge. The recommendation, the minutes need not be challenged. The final order is before this court. It's not a consequential order. Promotion and seniority.
That is
a
for
different
lordship to
aspect.
decide.
Yes.
My submission, I have a right to make my
Yes,
submission
your
to your lordship.
submission has taken. I have taken note of it, but you see, the principle has to also apply to the context of
Right,
your
my
own
lord.
case.
My-
These principles, these submission. I'm sorry. The precedents are all very contextual. It is
Right,
made
my
in the
lord.
context of those cases. Now, in your case, the facts is different. The facts don't fit in. Anyway, which is the next case?
The next one is also similar to that. But since the petitioners have been participating right from the beginning
Okay,
till
on
the end
that,
without
on
raising
that.
any objection, And my lord, my second authorities I'm relying upon is Manish Kumar Sahi versus State of Bihar and others, reported in 2010, volume 12, SCC, page 576, para 16, my lord. Here also I'm relying upon the the principle laid down by the apex court, my lord.
Yes, Mr. Lianshima.
Yes, my lord.
Page.
Page 584, para 16.
Yes.
Page 576, starting from page 576, and relevant para is 16, that is to be found at page 584.
Yes.
I'm reading.
Yes, please.
We also agree with the High Court that after having taken part in the process of selection, knowing fully well that more than 19% marks have been earmarked for Viva Voce test, the petitioner is not entitled to challenge the criteria or process of selection. Surely, if the petitioner's name had appeared in the merit list, he would not have even dreamed of challenging the selection. The petitioner invoked jurisdiction of the High Court under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. This conduct of the petitioner clearly this entitles him from questioning the selection, and the High Court did not commit any error by refusing to entertain the writ petition. Refer in this case, connection may be made to the judgment in Madanlal so and so. My lord, my submission to your lordship is that since the petitioners have been participating without raising any objection,
Yes.
and only after they found out that their names are not selected,
No,
then they
were-
only
he
have
was in the
begun to
valid
have a
list.
grief.
He was in the valid list. It's not that he was not.
Valid
It
list, of
is
course.
that he did not get it. Someone else get it. Where is that page, that list that you had? I'm
that
trying
list.
to find that page.
I do agree with lordship to
Huh?
that extent.
List is
Yeah.
at page number
Their
167.
names found in the valid list.
Page
167, my lord.
167. What is this list, Mr. Lianshima? Page 167. This is the valid list of applicants.
Valid list, yes,
So
of
this
course.
is of 8 October, 8/10/24. And after this, what happened? Selection took place.
My lord.
No, after this, these people were appointed as external experts. Now, this letter, of course, was not marked to the petitioner, so petitioner will not know that he has given these letters. Then the nomination had come. Then ultimately, when did the selection committee make the recommendation? Where do I find all these dates? Are they there in your affidavits? The recommendation of the selection committee?
Not specifically, my lord. All the paragraphs have been records, confidential records of the university may be called for.
No need.
If your lordship,
That at this stage, I don't think it is required.
if your lordship is of the view that the same are required, the same can be.
Where is your affidavit? Let us see what is your stand in your affidavit.
Can be. My lord, this is a copy of recommendation made by the selection committee, which has not been challenged by the petitioners.
They have not received it. David Lalwamkima is someone else, no?
Someone else, yes.
And Lalmundunga is the
Lalmundanga is
R6.
R6, yes, my lord.
And what are the names of the petitioners?
Petitioners are number 3 and number 6.
So they are there.
They are there, of course.
They're of course there. This makes his case stronger. His name has been recommended. Huh?
Recommended, yes. On the following page, out of the 6 candidates who appear before the selection committee, Professor Lalnundanga is unanimously recommended for the appointment as Registrar of Mizoram University.
Obviously, answer is
This-
very obvious.
This should have been
How
challenged,
will
my
he
lord.
challenge this, Mr. Lian Shima? He has never.
On the recommendation of the selection committee, my lord, appointment was made.
I know, but Mr. Lian Shima, these are your internal confidential documents. They are not before the they are not communicated to the petitioner for the petitioner to challenge.
My lord, once
the petitioner
appointment
has
was
challenged
made-
the final outcome of the selection. That
Once
is the
appointment was made,
But you see,
This
Mr.
can
Mr.
be-
Lian Shima, I mean, this document itself is creating a lot of doubt in the mind of the court as regards the fairness of the entire selection. These 3 persons, the experts at serial number 1, 2, and 3, they have been appointed by whom?
VC, of course.
That email has whose letter? Whose signature? R6. And they say
R6.
out of the 6 candidates who appeared before us, R6 is unanimously recommended for the appointment of Registrar of
That we
Mizoram
cannot deny.
University. I'm sorry.
On record.
I am not able to accept this. I'm very sorry. Yes, Mr.
Let the
Malhotra.
counsel for the R6
Yes,
be heard,
Mr.
my lord.
Malhotra, how do I save you? Huh? You're beyond repair now.
Beyond.
Yes, Your Worship.
I mean, you know, if you would have. Sorry, I'm talking to you. Sorry.
Yes, sir.
If at that relevant point of time when you've decided to contend for this post,
Yes.
you could have always step aside.
Yes.
There was no difficulty at all.
Yes.
But having not done that and having remained till the end, even taking you see, even you went to the extreme of being in that meeting. You may have walked out
Yes.
at that particular time, but at serial number 12, you are there.
Your Worship, I'll try my best to explain, as to in what manner there was no biasness in the actions of the respondent number 6.
But you see, it's not important.
Yes.
Bias is a very relative term. It's not important that in your eyes you don't find that you have not done any wrong. What is important is whether in the eyes of the others, the common men, everyone, would it appear that you have acted in a biased manner? The moment you are participating in the entire process of thereby selecting yourself, on the face of it, it will
Arbitrary.
always, whether you actually acted it in a biased manner or not, is no longer important.
Understand, Your Worship. Anyway, let me try to satisfy Your Lordship.
Yes.
Your Worship, I'll take Your Lordship to page 41 of the writ petition.
Yes.
141. Page 141.
Yes.
So, Your Worship, this is the notification issued whereby the respondent number 6, as soon as his tenure had expired, it was notified that he will continue to hold the post of registrar until new appointment is made or until further order, whichever is earlier, in terms of the statute number 4, bracket 4, subclause 4. So, my learned friend had already taken Your Lordship to page 62,
Yes.
and he had referred to statute 4, subclause 4.
Yes.
When the page 62, Your Lordship,
Yes.
when the office of the registrar is vacant or when the registrar is by reason of illness, absence, or any other cause unable to perform the duties of his office, the duties of the officer shall be performed by such person as the Vice Chancellor may appoint for the purpose. So, as soon as the post fell vacant, the respondent number 6 was appointed to carry on the duties of the register under statute 4, subclause 4.
But the R6 was also earlier also the registrar
Yes,
of
he
the
was,
trade.
after his tenure expired, he was again notified, there was a notification issued that he should continue to hold the post of registrar until a new appointment is made or until further order. So, to fill in the gap, he continued to hold the post of registrar. And at page 62, clause 7, Your Worship,
Yes.
the
Yes.
the registrar shall hold the registrar shall be ex officio secretary of the executive council, academic council, and the college development council, but shall not be deemed to a member of any of these authorities. He shall not be a member of any of these authorities, and he shall be ex officio member secretary of the court. So he'll be a ex officio secretary of the executive
What
council.
does this mean?
He shall not be deemed to be a member.
The registrar shall be ex officio secretary of the executive council, the academic council, and the college department council, but shall not be deemed to a member of any of these authorities, and he shall be an ex officio member secretary of the court.
So he was not a member of the executive council, but he was just the ex officio secretary. And page 63, Your Worship.
But does it change anything? Because you were sitting in that executive committee on that day at page 175,
Yes.
serial number 12. You were there.
I'll take your lordship to that. Page 63.
No, even if you're an ex officio, but in this meeting, the 66th meeting of the Executive Council, Mizoram University, you were very much present.
Yes.
Registrar, you're present.
Yes.
Correct.
As the secretary, Your Worship.
As the secretary, whatever, but you were present in that minutes, the minutes which ultimately accepted the recommendation of the selection committee. You are very much present
I
there.
understand, Your Worship. But the reason I was present is at page 63, Your Worship.
No, whatever could
Yes.
be, but your presence there has itself has tainted the whole process, vitiated the whole process. No,
But Your Worship, let me
you
try
see,
to explain this.
under subclause 4, you could have said that, well, since I am contending to the post now, I cannot perform the office anymore. There was no difficulty. VC could have appointed someone else, and that person would have carried out the duties of the registrar. The statute provides it.
I understand, Your Worship.
That would have been the best way.
I'm just trying to explain to Your Lordship why he was there and
No,
what were his
I
duties.
understand.
Yes.
You see, the problem is that all these explanations will not take us anywhere else, because at the end of the day, fact remains that you were sitting in that meeting.
You know, I'll come to that. Your
And
Lordship.
your
Yeah.
whole presence therein has now vitiated the process. And these letters, these are signed by you, not as some ex officio.
I understand.
So
Your
those 3 letters.
I'm-
Wait.
I'm just trying
One second.
I'm just trying to explain to Your Lordship why I was present in these meetings.
No, that I have seen, but where is that gone? Yes, 168. 168. This email is gone from you, Professor so and so,
But Your
from
Lordship
so
will
and
see,
so
Your Lordship
registrar.
will see the first paragraph.
Yes,
The selection committee for, I'm reading from page 168.
the
selection committee for the post of registrar
Mizoram
and
is
internal audit
scheduled.
officer is
For
scheduled.
this, the Vice Chancellor
Yes.
Mizoram has nominated the following.
It is
as
not.
an-
It is not the respondent number 6 who has nominated
but
these external.
he's the one who's communicating
Yes, that
it.
is there.
He's
Why
the
he
one
has
who's
com-
communicating it.
Your Lordship, I understand why he has made these communications.
Then you see, it is requested that comments, if any, be submitted to myself.
And
I'm using the word myself because
Your
it says
Lordship,
registrar.
because
Via email at so and so. If no
Why-
comment is received
why he
from
has
you,
made these
it shall
correspondence.
be considered as approved by you.
Your Lordship, why he has made these correspondences is at page 63.
No, that's because that is his part of his duty.
Yeah, part of his duty.
I understood.
Yes,
That is why
yes.
my immediate reaction is that
Yes.
what prevented you from stepping down? Because then the VC would have appointed someone else to do your duties. You did not go through these embarrassments.
I understand, Your Lordship, but then, I mean,
And most importantly, 170. The selection committee for the post of the registrar and internal audit officer, Mizoram University, is scheduled to be on so and so. For this, the VC so and so has nominated the so and so. And in terms of so and so, these people have been considered and approved.
Yes.
And who signs it? The registrar.
Your Lordship, because it is his duty as the secretary. It is his duty. That is why, Your Worship, the
Yes,
duties of the
anything more?
registrar.
Anything more?
The duties of the registrar are given at page
Okay,
63.
noted. Noted.
Yes, so it is as per his duty.
Very well.
The nominations were
You
made
have
by.
acted as per the duty assigned to you under the statutes.
Yes.
And you have not done anything which is
the
outside
experts were
your.
the experts were nominated by the VC,
Very
not
well.
by the R6, and even in the 66 meeting, which had considered the recommendation of the selection committee as per the affidavit by the university, Your Worship, the recommendation was in a sealed envelope, and it is not that the executive council had sort of considered it piecemeal, and I was present. It is as per
Where
the
have you
affidavit.
said that in your affidavit?
Yes. Even the state, even the MZ, the university, in the affidavit have clearly stated.
Where is that?
Okay.
I would like to give the dictation right now, but if I do that, then the other matters will not be, I'll not be able to. So what is to be done? We will continue with this tomorrow because it's already, maybe we'll finish the arguments and we'll keep it for tomorrow for delivering the judgment in the court so that
yeah.
then I can finish the other matters as well.
Para 22 of the affidavit filed by
Para?
R6. 22.
22. 22 or it starts from 21. I think from 21 also it may be important, no, Mr. Malhotra?
No, para 21.
Page 12? I don't know which. Oh, this is a rejoinder. This is. I think I've not got the correct affidavit. This will be Mizoram University's affidavit would be respondent numbers.
R1 to R5.
Okay, I've got it now. Yes,
Hello.
para 22. Yes.
Para 22 of my affidavit as well as the affidavit of the university, Your Worship. Oh.
All right. He was in attendance in the meeting but went out while selection committee minute for registrar post was considered as usual practice.
Yes.
Okay. Anything more?
Yeah, we cannot deny the fact that he was there, but yet, because in his capacity as the secretary, he was present, and as per his duties, he had sent out the emails, he had signed the documents. But that does not mean that he had interfered in the selection process.
So in short, what you're trying to submit
Yes.
is that it is the VC who had selected those three experts.
Yes.
It was the R6 who only communicated the recommendation of VC appointing them to them,
Yes.
and also circulated for objections.
Yes.
And having not received any objection, he finally approved the appointment
Yes.
of these three experts
Yes.
and communicated it with them.
Communicated them.
And then when the recommendation has finally come,
Yes.
by virtue of his office, he was
Present in the-
there. But when the consideration took
Took
place
place.
for
The recommendation
for
of the
recommendation,
selection committee was open.
he went out.
He went out. And Your Worship,
Is that reflected in the minutes anywhere that he had walked out?
that Your Worship, I think my learned senior friend had just handed over the minutes. No, that is only the minutes, Your Worship. He was not present in the selection committee.
No. Where is that?
He was not present. This shows that he was not present in the meeting of the
this is
selection
what,
committee.
Correct.
Yes.
The affidavit shows,
Yes.
but in the minutes, is there anything in the minutes that he has gone out? He has no. That is not there.
Yes. That, Your Worship, unless the records are called for.
No, it's not there. The affidavit doesn't talk. There's nothing to substantiate that fact In any case, it's admitted that otherwise he was there. Even you admit that you were there,
His
but you
signature-
walked out.
His signature's there.
Correct. That is what. And not only that, in the affidavit also it is admitted that you were there, but you walked out.
Yes,
This is the stand.
yes. That is the stand.
Difficult. Very difficult.
Yes, I-
Especially in today's context, it is more difficult.
Your Lordship, but what I'm trying to, Your Lordship, satisfy Your Lordship is that my presence was required because of my position.
But
And-
Mr.
and
Malhotra,
the duties imposed upon me by the statute.
answer to your argument lies in clause 4 of the statute.
Your Lordship, I could not have gone to the VC and say that, no, I'm
No,
I'm
because
going
you
to-
could have. If the VC did not, in fact, it was not in the VC's interest also. It was in your interest. If you want to ultimately get this post, for temporarily, you should have said that, well, I've contended, so I cannot perform my post any longer. And then VC, obviously, that power itself there is there in the statute, or for any other reason, if you cannot function your post,
But that is, Your Lordship,
he
that
could have
is-
appointed anyone
It
to
is not-
perform your duties.
it is not the case of the petitioner that the respondent number 6 should have recused himself from the post.
No, he
when
did not.
When he intended to
That need not be
participate
his
in the
case.
selection process.
That need not be his case. He's on a larger issue. That need not be his case. That was for your benefit that you should have done it. And the fact that you are giving you are raising an argument that, well, because of this I am there.
Yes.
So that is why I'm pointing out that the statute, the answer lies in the statute itself. There was a way for you to, in a dignified manner, step out and not participate till the final selection is over.
Anyway, Your Lordship, I can't argue with
see,
that. Your Lordship,
that
but-
is what is disturbing me.
Yes.
Otherwise, you are absolutely right. The respondent number 6 may have signed it, but it is not his decision to bring these 3 persons.
Yes.
It was the decisions of the VC. You have communicated. This I have
Yes.
taken note, but I am still not being able to ignore the
Meeting.
presence of you.
66th emergent meeting. Anyway, Your Lordship, just one case I'd like to rely on,
Yes, please.
and it's on the same lines. My learned senior friend and
Yes.
Your Lordship, I'll take Your Lordship to paragraph 21.
21. Yes.
It is the same thing. A candidate who has participated in the selection process adopted under the 215 rules is estopped and has acquitted himself from questioning it thereafter, as held by this court in the case of Anupal Singh Supra. I'll take Your Lordship to paragraph 56 in italics. Observing that the result of the interview cannot be challenged by a candidate who has participated in the interview and has taken the chance to get selected at the said interview and ultimately finds himself to be successful. In Madanlal versus State of J&K, it was held as under. The petitioners also appeared at the oral interview conducted by the members concerned of the commission, who interviewed the petitioners as well as the contesting respondents concerned. Thus, the petitioners took a chance to get themselves selected at the said oral interview. Only because they did not find themselves to have emerged successful as a result of their combined performance, both at written test and oral interview, they have filed this petition. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or selection committee was not properly constituted. So here also, Your Lordship, it's a question of he has challenged the 3 external efforts. But after taking part in the interview process, he cannot turn around now and challenge the selection committee.
Where
was
are
not-
these objections in the counter affidavit? And Mr. Joseph, I would like you to point out from your rejoinder where you responded to this part of the argument, that you have not objected. Mr. Rianshima, in your counter affidavit, or Mr. Malhotra in your counter affidavit, which paragraph?
Regarding the selection process? Your
Yes. No, regarding that, the maintainability. Just give me the paragraph numbers
Para 4.
in your,
Yes.
and Mr. Lian Sharma,
Para 3 and 4, Your Worship.
Mr. Lian Sharma, in your affidavit,
Para 3, my lord.
para 3.
Yes, my lord.
Okay. And in the other affidavit, it is
Para 3 and 4.
3 and 4. AO by R6.
Yes.
Three. Okay. Yes. Anything more?
Yes, Your Honor, in the rejoinder affidavit, the petitioner has stated that he was not aware of the 3 experts in the selection committee. That's why he did not have a chance to challenge it earlier. But that is not the case in the writ petition.
I want to see that
Yes.
what they have said. That's all. What do you mean by it was not their case?
In the writ petition, the stand taken by the petitioner in the rejoinder is not the stand taken
That
in
they
the...
didn't
Yeah,
know.
they are adding to it. In the rejoinder,
No,
they are-
perhaps I don't know what has been said, but what
Yes.
perhaps they might mean is that at that moment they didn't know.
yes, later on they
Because
came to
it
know.
is not expected for the candidates to know also.
But Your Worship, that is not the stand taken in the writ petition. Now, in the rejoinder, they have come up with that. They were not aware. But they should have included in the writ petition itself.
Okay.
They're improving the writ petition.
They are basically responding to the maintainability objection raised by you.
Yes. But that is that. They are responding to that and they
At the
improve.
time of drafting the repetition, perhaps they were not thinking that you would be
Yes.
questioning the maintainability.
Now they-
And the fact that their knowledge, when it came to their knowledge about the participation of the R6, would be of some relevance. That could also be a situation. Anyway,
Yes.
the-
They have improved their stand in the
all
writ
right.
petition in the
Noted.
rejoinder.
Noted. Yes, Mr. Joseph, which paragraph is that?
My lord, regarding the reply that I made, my lord, that is in the in our affidavit, my lord, at paragraph number 2,
This is the rejoinder against 1 to 5.
1 to 5. And
Paragraph?
similar- this
Paragraph?
is paragraph number 2, my lord. Because in our prayer, my lord, we have, if your lordship will see our prayer,
1 second.
yes, my lord, because I think that objection was slightly, I think that has overlooked our prayer.
1 second.
Yes.
And in the other affidavit?
In the other affidavit, my lord, let me see. That's in the other affidavit also, my lord, at paragraph number 3.
Okay, fine.
And paragraph
Now-
number 4, this is with respect to the estoppel point they had raised, my lord. Because estoppel
In the second rejoinder.
in the second rejoinder, this is because only the respondent number 6 had raised this point.
Okay, paragraph.
Paragraph number 4,
The one which starts with that the statement made at paragraph
number 4, yes.
Okay, yes, Topal. Yes, I've got it.
Because estoppel can only operate, my lord, when we have full knowledge. These are all confidential, my lord.
Now, prayer, you want to show something?
Yes, my lord. In my prayer, your lordship will turn to page number 31.
Yes.
Now, 31 goes on, my lord. We have mentioned all the documents we have in our possession, and thereafter at page number 31A, my lord, if your lordship
These
will turn-
minutes and all are challenged.
everything is challenged. At page number 31A, if your lordship will see,
Yes.
we have mentioned out of abundant caution, my lord, by which the respondent number 5 was reappointed to the post of a registrar, as well as all connected documents pertaining to the recruitment and reappointment of the respondent number 5 to the post of registrar, Mizoram. So, my lord, it cannot be said that we have not challenged, because these documents, my lord, in fact, I have not seen them with my own eyes till today.
In the appointment order, it is clearly mentioned on recommendation of the selection committee. It's black and white in front of their eyes. They fail to challenge it.
Okay. What was the deputation thing that you were saying?
Now, my lord, the issue with respect to
Where is that paragraph?
my lord, deputation is, my lord, with deputation, I'll have to take your lordship one by one, my lord, because that
No,
is.
but just point that paragraph number.
Simplify it. The learned petitioners council is relying on office memorandums issued by the central government. That the deputation period can be only for 5 years. It can be extended for 2 years. And that is an OM. My sir, is meant for central government employees,
Not for.
not for.
Let
Anyway,
me- let-
I
let
don't
me-
know.
let-
if
All
I-
right, anyway, all
it's
right.
better- hello.
I'll fix this matter for tomorrow now, huh?
Yes, if required, my lord can ask for tomorrow, we can substantiate.
Let me have a look at it.
Yes, yes.
Because I don't feel very comfortable in keeping these matters reserved. I want to dictate it in court in presence of the council.
Just one submission. I have a fixed matter tomorrow in court number 1.
It's all right. You just have your juniors
Yes,
here.
my junior will
I'm not fixing it for any
argument.
arguments. For the purpose of giving the judgment.
Yes.
In case any clarification required, this court will certainly accommodate you.
I'm
Because Thursday is a holiday.
yes.
And Friday would be my last day in the Aizol bench. I have from the next week again. I'm posted at
Got it.
principal bench.
Principal.
So it's difficult to carry this whole file with and then keep it there, and it'll only delay. Now everything is fresh.
Yes. Your Worship, my junior will be here.
Just ask your junior to
Yes.
be here, Mr. Lianshima. You can ask your junior.
My lord.
But Mr. Joseph Lalchinama.
Lalsan Imam.
The Learned Counsel appearing for the petitioner. Also heard Mr. A.R. Malhotra, Learned Counsel appearing for respondent number 6, and Mr. Lian Shrima, Learned Senior Counsel, LH Lian Shrima, Learned Senior Counsel, assisted by MS Ruth. Ruth Pela.
You got the name right, man.
Sorry? Sorry?
You got the name right, yes.
For the respondent number 125, na?
Yes.
1 to 5. Hearing remains concluded. Matter reposted for tomorrow for making an endeavor to to dictate the judgment in the open court.
Obliged,
Okay?
my lord. Deeply obliged.
Repost on such and such date. Or delay to.
Item 2.
This now this one Joseph's. Yeah. No need. No need. Yes. He'll keep it. You take everything and put it in the chamber. Yes.
May it please, Your Lordship, I appear for respondent number 6. My Lord, I have the authority to represent respondent number 6, and I will file vakalan at within today.
All right.
My lord, if that is the case, if my learned friend is representing respondent number 6, I think it would be best if she would also gather instructions as to whether she would represent respondents number 7 to 9.
All right. They're connected. You find out.
Yes, yes, my lord.
I will
because-
not put that in my order. It is for the parties to choose. If the other parties do not want to engage her, we cannot put that in the order. She will communicate. You communicate.
Yes, my lord. Why I have raised this because
I understand there must be some
Yes.
connection.
Correct.
I got you. But at the same time, it is not correct for the court to put that in the order, you see.
Correct.
If they are not coming, because you are perhaps saying that because it would expedite the process.
correct. And since they are the sub branches,
Who are the remaining respondents?
the respondents are the sub branches of the association.
Are the
Of the sub branches of the association.
sub-branches
Yes.
of the
Of
R6?
the respondent number 6. Respondent number 6 is the main Central Young Mizo Association, and respondent number 7 to 9 are the branches within the locality.
Okay. Heard Mr.
Eldrin Zoutan Moya.
Eldrin Zothan Moya.
Correct.
Senate Counsel appearing for the petitioner. Also heard MS.
Ronald Sandame.
I know your name. Lalun Louis.
Yes, Your Lord.
Right? Yes. Learned State Counsel for respondent number
1 and 2, Your Lordship.
1 and 2. And ma'am, your name?
Your Lordship, 1 to 5.
1 to 5. And yours?
Vanlal Sandame, Your Lordship.
MS?
Vanlal Sandame.
Vanlalsamni,
Yes, Your Lordship.
learned counsel for respondent number 6. Upon so and so entering appear so and so he that ticket number no koba eno bujan koba to tapsat koba so and so enters appearance and submits that she has received instructions to appear for respondent number 6 and accordingly shall file power thereof.
Your Lordship, on
She
behalf of State Respondent 1 to 5, Your Lordship, I'll be filing my affidavit opposition by
I'll
next
give you
week.
time. Wait. Mr. So-and-so learned counsel still for the petitioner draws the attention of the court that the R7 to 9 are the members,
Sub branches.
sub branches of the respondent 6 Central Young Meso Association.
Correct.
And therefore, the same may also be represented by learned counsel appearing for R6. MS so-and-so shall also obtain instruction in this regard. MS so-and-so learned state counsel seeks further, no, but 2 weeks, 3 weeks,
Your Lordship, 1 week would suffice.
1 week time to file return in the matter. Repost after a week, give a date. Repost on such and such date.
8th of June.
Deeply obliged.
Item 3.
My lord, this is a subsequent bail application after the earlier one was rejected by the
Was the
special
second
court.
time?
Yes, Your Lordship.
What changed circumstances?
Your Lordship, my main points are regarding non-compliance of Section 48 BNSS as well as Section 47, my lord.
And what about, are you saying the grounds of arrest is not given?
Yes, arrest intimation given to the relative, no grounds was mentioned. Plus, besides that, Your Lordship,
Has
signature
the
of...
grounds been given to you?
Yes, Section 47 was, but not fully complied, my lord.
Why?
That is
Why?
also-
You see, because Mr.
Yes.
Landramenga,
Yes, my lord.
this court have also authored 1 or 2 judgments refusing grant of bail.
Yes,
I think Ms. Fenai had appeared in those cases.
Yes.
Wherein these procedural violations have been urged. But I think there's there's a decision of the Apex Court also, because these are ultimately matters of trial. However, if you show there is a violation of 22.2, 22.1 or 22.2
Yes.
or 21, then the situation then of course this court has no choice but to release you, because these are constitutional fundamental mandate that has to be followed
I
by
understand.
the arresting officer.
yes.
But if your case rests upon some procedural infraction, then these are matters of trial. They cannot be gone into the at the bail stage.
But
I'm
also by-
making myself very clear to you at the beginning.
Yes.
And top of it, this is the second time that you are coming. So there is has to be some change circumstances.
Yes, Your Lordship, and moreover, I am relying upon one medical certificate as well, my lord. I
For
have
what?
given to the. And before coming to my points, this is the new issue, the development which has cropped up, Your Lordship.
Yes,
It was written on 22nd May
yes.
by the medical doctor. It says that, Your Lordship, this is to certify that Mr. So-and-so, he is the present petitioner, who is currently at ward so-and-so jail, is suffering from 3rd-degree piles with external piles. He was referred to surgery department, civil hospital for his condition on 28/4/2026, 29/4/2026, 5/5/2026 and 7/5/2026. Bending was done on 29/4/2026 and he's
Is
advised
he
to
not
undergo.
getting the treatments? The jail authorities are not giving him treatments?
Yes, at the higher centers outside jail, it is highly
No,
recommended.
because it's an NDPS case, right?
Yes, although
So
what
how
I'm
come-
trying to
wait,
submit,
wait.
although rigors of Section 37, Your Lordship, this is what I'm just to.
No. So then 22C and the 37 rigors are applicable. First time, that is why bail was rejected.
Yes.
Is it your case you're not getting treatment?
Yes, he could not be treated inside jail.
Huh?
That is what. He could not be given treatment inside jail.
Miss Mary, have you found out?
Your
Treatment
Lordship,
given or not?
I was served a copy of this only 1 hour before, so I
Oh,
haven't.
then you take instruction. Let her take instruction. I'll
My
post
lord.
it next week.
My lord.
Let her take instruction. Heard Mr. Lalremenga, Learned Counsel appearing for the petitioner. Also heard MS Mary, Learned EPP for the state respondent. Mr. Lalremenga submits a letter written by the medical officer, Central Jail, Aizawl, on 22nd May 2026, certifying that the accused petitioner is suffering from third-degree piles and with external piles, and immediate surgery is needed, is required. MS Mary submits that she has been given a copy of this. No? This was given to you sometime before or what?
1 hour before.
This letter.
This letter.
The aforesaid letter was given to her only during court, and accordingly seeks a short time to verify the same. Repost on such and such date.
2nd of June.
Much obliged.
Item 6 from the supply list.
This is that appeal.
Yes, my lord. Hence, my learned,
I'll admit it, Miss Linda. Huh? Heard Mr. Lalpakwala, Learned Counsel appearing for the appellant. Also heard MS Linda, Learned PP for the state respondent. By way of this appeal, under section 4152 of BNSS 2023, the appellant is assailing the impugned judgment and order dated 24/3/26 and sentence order dated 27/3/2026 passed by the Learned District and Session Judge Aizawl, Judicial District Aizawl, in Sessions Case number 51/2020 in criminal trial number 952/2020 under section 324 IPC, read with section 25(1)(b)(a), 27(1) Arms Act 1959. Do you want me to record the I'll admit it simply.
Yes, my lord.
Admit, call for case records. Anything more?
my lord, I have filed
IA is
IA,
there, my lord.
sentence suspension and bail.
What is the maximum sentence you've got? 5 years?
3 years here.
3 years.
3 years I have been given.
Are you carrying that decision of the apex court limit when the sentences are for fixed duration?
I have carried the order of your lordship.
Huh?
I have carried the order of your lordship.
Give. Any objection here? It's a fixed
my lord.
duration.
My objection may be recorded.
What is your objection?
Since the trial court has rightly or wrongly convicted him, my lord, he should be
Right,
not
or
be
wrongly objected?
convicted him
No,
already.
I'm not on conviction. That of course.
Suspension of sentence.
Correct.
That's his.
This is we are only on suspension.
Yes, suspension may not be given since he has already been convicted in the case.
During trial, was he on bail?
He was on bail.
Yes.
Conviction cannot be suspended. Sentence of imprisonment can be suspended. This is in the case of PC Act, my lord, the one which your lordship has granted bail.
Yes, take down. Heard Mr. Lalpakwala, Learned Counsel appearing for the applicant. Also heard MS Linda, Learned PP for the state respondent. This is an application under section 4301 BNSS 2023, seeking for suspension of sentence imposed upon the appellant accused by the learned additional district concession judge Aizawl Judicial District Aizawl vide sentence order dated 27/3/2026 in session case number 51/2020 criminal trial number 952 of 2020 registered under section 324 IPC read with section 25 1B A 27 1 Arms Act 1959. Whereby the applicant was convicted under the said sections of law and by sentence order dated 27/3/2026, he was sentenced to undergo simple imprisonment of 6 months imprisonment and to pay a fine of rupees 2,000 for the offence under section 324 IPC and 1 year rigorous imprisonment and to pay a fine of rupees 2,000 for the offence of under section 25(1)(ba) of the Arms Act 1959 and 3 years rigorous imprisonment and to pay a fine of rupees 2,000 for the offence under section 27(1) of the Arms Act 1959. Councils, you may please take your seats.
Malad.
Mr. So-and-so, Mr. Alfaq Jwala, learned counsel for the applicant submits that during the pendency of the trial, the applicant was on bail and that by the aforesaid impugned judgment and order, he has been convicted and sentenced for a fixed term, which is below fixed term, full stop. He further submits that the applicant has good grounds of appeal and has every chance of succeeding in appeal. Therefore, unless the impugned judgment and order of conviction, impugned judgment and sentence is suspended during pendency of the trial, pendency of the appeal, he may also be, he shall suffer irreparably. MS Linda, learned PP for the state respondent, fairly submits that there is nothing on record to indicate that the applicant has taken undue advantage of the bail granted by the trial court. Bail granted during trial court, because we don't know who gave it, no? During trial. Stop. However, she submits that the conviction being based on evidence, the sentence ought not be suspended. Having heard the learned counsels appearing for the parties and having perused the materials available on record, it appears that the grounds urged in support of the appeal are arguable and would require further examination. Considering the totality of the matter, it is hereby directed that the impugned judgment and order of conviction, impugned judgment and order, impugned judgment,
Sentence order.
impugned sentence, so and so shall remain suspended till final disposal of the main case. Were you already in bail, or after this you have been?
No, I was on bail during trial.
So you then you are allowed to remain on bail?
Yes, my lord.
The applicant is allowed to remain on bail on the terms and condition imposed by the trial court. Do you have the order of the trial court?
I have incomplete bail order that is at page 57 to 58 in the sentence application, my lord.
50?
57 and 58.
So this is ordered at 13/6/2019.
Yes, my lord.
19. Till disposal of the connected appeal. Interlocutory application accordingly stands disposed of.
I'm deeply obliged. I'm obliged, my lord.
Yes.
(18.6). Item 7.
Which is item 7?
May I please your lordship?
Yes. Mr. Ali.
Lordship, yes.
Yes, Mr. Ali?
Accused Hassan Ali was arrested on 1/3/2026, Your Honor. We have filed this bail application on two grounds, Your Honor. One is that 47, 48, and the another is 48 BNSS, Your Honor, Your Lordship. That when
These are procedural.
yes, Your Honor.
Dekha.
Your Lordship.
Okay. Yes, Mr. Ali.
Your Lordship,
My first and I'm sorry. Before even if you start, I wanted to ask you: your ground is on violation of Article 22 too?
yes, Your Honor.
So you are saying
Yes,
that the
Lordship.
grounds of arrest is not given to you?
Yes, Lordship.
Where have you said that, and how do you show it? Do you have the arrest memo? From where
Yes,
are you
Lordship.
saying?
In paragraph 10, Your Lordship, in page number 14. 14 is also in paragraph 8 also, Your Lordship. Page number 12, paragraph 8.
Now show me any documents is here where
That
have you
is-
annexed the memo of arrest or anything?
That is exhibit 4, Your Lordship, page number 26.
Page number 26.
Yes.
This is written in what language?
It is written in English language, Your Honor, Your Lordship.
that ground-
Subsequently, it was written by the accused person. That is a mere confessional statement, Your Lordship.
Miss Linda, this is similar to yesterday's case.
Yes, Your Lordship.
my lord,
I think Miss Vani
similar.
was there.
Yes.
Why in all these cases now that in your grounds of arrest you are making the accused right?
My lord, the problem is they don't know how to write in Hindi or Bengali, so they let
no.
them write it themselves. So it should have been written some other way, but
This is the ground
yes.
of arrest, right? Now here what is said, you are hereby informed that 15 so and so, so ground is mentioned, isn't
So, Your
it?
Lordship, that is the only information. Ground of arrest and information is totally different, Your Lordship.
What more information you want?
That on what ground the arrest was
Yes,
necessary, Your
the ground is given. You are hereby informed that 15 small bundles of suspected methamphetamine weighing a total of 3383 kgs were recovered from your driven vehicle, Tata truck, so and so, so and so, so and so, so and so, possession of this leading to a crime under section so and so. As you are the driver of the vehicle and transporting Mr. Ali, I'm telling you, this ground of yours will lie flat on your face. This is very much given. You are fortunate that so much is there. What more you need? For grounds of arrest, now they are not going to give you the entire story. Sufficient understanding have been given to you. In fact, they went to the extreme of giving you the weight of the drugs that has been seized also. What more information you want, Mr. Ali? Do you have anything else? Because this I'm not going to accept.
There is another
Yes,
another
please,
aspect, Your
yes, please.
Lordship. That is
Mr. Ali,
BN
you are understanding, no? Because you see,
Yes.
when you urge about violation of section Article 22(2), you must, in those cases, generally, there is no information as regards the facts, okay? Because
Yes.
at the end of the day, if a person is arrested, brief facts why he is arrested should be there, so that he
Yes,
knows
Your
that because
Lordship.
of this I am being arrested. Now here it has been clearly given. More
Now,
than this,
turn to
you see,
page
more than
27.
this, at the time of arrest, you cannot even expect an investigating officer to give you.
Lordship, Lordship, may I bring Your Lordship to page number 27, Your Lordship?
Yes.
Annexure 5, that is 47 notice, Lordship. 48, Your Lordship.
27. Yes.
That is also not complied properly, Your Lordship.
Why?
Uh,
Who is Hassan Ali?
Hassan Ali is the accused person, Your Lordship. Hassan Ali is the accused person. This is to inform that in connection with the above mentioned case, your brother Hassan Ali is son of so and so. Now, so and so has been
And in,
arrested. You may engage a lawyer to represent him. His family members are residing outside the state, and since they cannot come to Saitwal police station, the information of his arrest has been conveyed to his brother Sanwar Hussain. Phone number so
just
and
one
so.
second, Mr. Ali. Just 1 second. Miss Linda,
Yes, my lord.
you see, I'm coming back to page 26 because it appears that the accused is familiar with Hindi language. He does not know English,
Yes.
right? Now, in document 20, in page 26 document, from where one can know that you have explained him in Hindi, the grounds of his arrest. Where do we get it? Because it has to be communicated in a language that he is familiar. He only appears to know Hindi. He's not familiar with English. Correct, Mr. Ali?
Yes, Your Lordship. Yes.
So the grounds of arrest in English, it is very much there. There is no quarrel about it. But what about the language that he is familiar? Because now if you come back to 27, see, you are writing it there. The content above is explained to accused in Hindi language which he knows.
Hindi language,
But this
yes,
is
yes, sir.
this is under section 48 notice. This notice you are saying this is to inform that in connection with the above mentioned case, your brother Hussain Ali has been arrested. You may engage a lawyer, and at the end of the day, who is signing it? The accused.
That's true, my lord.
This is again. There seems to be. I think yesterday's judgment.
Yesterday, Your Honor, it was there was a matter, item number
Yes,
16. Item number 16, Your Honor.
You've been following this court.
Yes, Your Lordship.
Where are you appearing from?
I am appearing from Kokrajhar district, Your
Kokrajhar.
Lordship.
Very
Kokrajhar,
good.
yeah.
Very good. I'm happy to see that from such distant far places also now people can connect through video conferencing mode
Yes,
and appear
Lordship.
before the Constitutional Court. It is in fact wonderful.
Grateful, Lordship.
Michael, can you get me this? Bail application number 624 of 25. I want a copy of this. No, this is Justice Silo's judgment. Yesterday it was relied. Miss Linda, do you have Justice Silo's judgment? Do you have a copy of that? The one
don't
which
have with
was
me right
relied
now.
yesterday.
My lord, I don't have with me right now.
Can you not take it out? Ask the library to, they'll give you a print. They'll give you a print. So what to do, Miss Linda?
It's up to your lordship, but since it's a commercial quantity, some stringent provisions may
No,
be given.
you see, on the face of it, if you want to verify, I can post it tomorrow for your satisfaction, but you can't improve these documents.
That's true, my lord.
If
I
you
have-
have something else, you can show me, but because 26 doesn't show that he has been explained in a language he is familiar, so there is a direct violation of Vihan Kumar, Mihir Shah and Pankaj Bansal and all those decisions, right?
Yes, my lord. I've already
then-
talked to the IO also, so. there is
And
nothing
then
more
when you
than
come
this.
to the 48 notice, this notice is not given to the accused relative. It mentions that your brother, but it is actually signed by the accused. So
He
then
was
the
contacted only through phone calls.
phone, but where are the details? Where have you given those details? Yes, take down. Heard Mr. Saket Ali, right?
Yes, Your Lordship.
Learned Counsel appearing through video conferencing mode. Also heard Mr. MS Linda so and so, learned PP for the state respondent. By way of this petition under section
483, Your Lordship.
ভাৰ্গৱ তুমি এইটো ল'লা সেইটো তোমাৰ চেছ কৰিব আছে কিন্তু by way of this application under section 483 of the code of BNSS 2023, the applicant I Hossein Ali is seeking regular bail, who was arrested on 1/3/2026 in connection with Saitwal Police Station case number 20 of 2026, registered under sections 22C/25/29 of NDPS Act. Ms. Linda, most of these drugs cases comes from Saitwal. Why?
Yes, my lord.
Because coincidentally, I just remembered even yesterday one is
Yes.
also of Saitwal. But then you sensitize those investigating officers there.
Yes, my lord.
These
We
are,
have to.
you see, these are commercial quantities, and at the end of the day, because of the constitutional mandates not being followed, then the constitutional court will have no other choice but to
Yes.
give them bail. And this is only because they are not following it.
Yes, sir.
Now we don't know if these are being done purposefully or not, or what. Because when it has to be explained, that's all. You explain it, you follow it. Why so much difficulty in following the mandate of the Constitution? Isn't it?
Yes.
I think it's time for you to sensitize these IOs. The brief facts of the case is that the petitioner that on 1/3/2026, the informant lodged an FIR alleging inter alia that on 28/2/2026 at around 7:30 p.m. one ASI H. Lalpeklum along with his party left PS to conduct random checking at Kulmawi Kefang. During the checking, a vehicle bearing registration number AS01 NC 8361 driven by one Hossein Ali proceeding from Manipur towards Aizawl arrived and intercepted at around 6:20 am on 1/3/2026 at Kaifang, Kulmawi, Aizawl Road, about 2 kilometers south of Saitwal PS. Upon checking of the said vehicle, they found a bounding transparent polythene suspected to be contraband items concealed inside urea box. On the basis of this recovery, they strongly, upon the same being suspected that, don't say this. You have to be, Mr. Ali, you have to be careful when you're drafting your paragraphs.
Lordship.
Be more careful next time. Where do I get these facts in the annexures?
Annexure, Your Lordship,
The brief facts of the case is that page 23.
page number 23, Your Lordship.
Ki kola? Last ki kola? Upon. On the basis of, accordingly, they suspected that more illegal contraband items may be concealed inside the vehicle. Accordingly, ground of belief as per section 42 of NDPS Act so and so, and upon arranging two independent civilian witnesses, a detailed search of the said truck on 1/3/26 at around 7:30 p.m. was conducted, wherefrom they recovered and seized 15 small bundles containing substance suspected to contain methamphetamine tablets concealed inside the truck urea box and wrapped in transparent polythene. Each bundles contained 10 sachets, and each sachet was found to contain 202 tablets comprising 200 red tablets and 2 green tablets within bracket, making a total of 30300 tablets suspected to be methamphetamine wrapped in yellow polythene. The said contraband items were seized from the joint possession of Hossein Ali within bracket 21 stroke the present applicant. Accordingly, the items and the vehicle were seized, and a case being registered, the accused appellant was arrested. Mr. Sakit Ali, learned counsel for the petitioners, assails the legality of the petitioner's continued detention, not on the merits of the prosecution allegations at this stage, but on the foundational ground that the arrest itself stands vitiated by non-compliance with the constitutional and statutory safeguards governing arrest. It is submitted that the constitutional mandate embodied under Article 22(1) and 22(2) of the Constitution of India, read with Section 47 and 48 of the BNSS, has been flagrantly breached. He contends that the so-called notice of grounds of arrest does not indicate that the arresting authority has informed the grounds of arrest in a language known by the petitioner. He further submits that the petitioner is familiar with Hindi language, correct?
Yes, Your
Familiar with Hindi language and does not know
Knowing English language.
and does not know English language. He further submits that the statutory obligation of informing a relative, friend or person nominated by the arrested individual has likewise not been complied with, drawing attention to the purported arrest intimation under Section 48 of the BNSS. Learned counsel further submits that the said document is not acknowledged by any relative of the petitioner, but instead bears acknowledgement attributable to the petitioner himself. The contention is that an intimation addressed to a relative but neither served upon nor acknowledged by such relative cannot amount to meaningful compliance with the constitutional safeguard intended to enable prompt legal assistance and defense, and effective defense. In support of the aforesaid submissions, reliance has been placed upon the following upon the decisions of the Apex Court in Pankaj Bansal versus Union of India, reported in 2024, Volume 7, SSC 576. Vihan Kumar versus State of Haryana, reported in 2025, SSC Online, Supreme Court 269, and Mihir Rajesh Shah versus State of Maharashtra and others, reported in 2026, Volume 1, SSC 500, as also the decisions of the coordinate benches in Azizur Rahman and Aziz versus Azizur versus State of Assam, in bail application number 624 of 2025, Hemkochen Tothang versus State of Mizoram in bail application number 20 of 2026, and Mr. Dotlang L.S. Lilin versus the State of Mizoram in bail application 31 of 2026. Per contra, learned PP submits that the petitioner was duly informed of the grounds of arrest, and that intimation regarding his arrest was also conveyed telephonically to his brother. Correct? To the brother, no? However,
Correct.
upon specific query of the court, learned additional public prosecutor fairly submits that no contemporaneous material has been placed on record to substantiate such compliance. It is nevertheless contended that the documents on record substantially indicate compliance with the statutory requirements. Having heard the rival submissions and upon perusal of the materials available on record, the principal issue which arises for consideration is not whether the prosecution possesses prima facie incriminating material against the petitioner on the merits of the accusation, but whether the petitioner's arrest and consequent detention satisfy the minimum constitutional safeguards that must precede lawful deprivation of personal liberty. Upon examination of materials placed on record, this court finds that the purported notice under section 47 BNSS does not on its face disclose any communication by the arresting authority informing the petitioner of the grounds of arrest in a language familiar, in a language which he understands. In fact, it is observed that the petitioner himself have written in Hindi. What is this that is written in Hindi? Can you read, Mr. Ali?
Not Hindi, Your Lordship. It is in Assamese.
What is it written?
More gari drugs loi ahote police dhorise aru police koise ukil dhori e bail hobo buli kotha bujai. That much, Your Lordship.
Then you say, ki koisa? Has confessed in the said purported 47 BNS's notice in Assamese language to the effect that he was caught with drugs while traveling in his car. Correct?
In his truck.
In
Your
his
Lordship.
truck. In his truck.
Yes.
Such a recital cannot be equated with communication of grounds of arrest by the arresting authority in the manner contemplated by constitutional and statutory mandate. The investigating of it is imperative upon the investigating officer to inform the grounds of arrest in a language familiar, in a language which is known to the accused petitioner. Though the grounds of arrest is stated in English in the said purported notice, however, it is clear, it is clearly established that the petitioner is not familiar with the language of English. Hence, a heavy duty was cast upon the investigating officer to explain the grounds of arrest to the petitioner in Assamese or any other language that he is familiar with. Communication of the grounds of arrest is not an empty procedural ritual. It constitutes a substantive constitutional safeguard intended to ensure that the arrested individual is made aware with sufficient clarity and certainty of the legal and factual basis upon which his liberty is being curtailed, so as to enable him to seek appropriate relief, recourse at the earliest opportunity. A document that merely records an alleged admission or statement of the accused cannot substitute the constitutional obligation resting upon the arresting authority. Equally, next paragraph, equally the material placed on record does not demonstrate due compliance with section 48 of the BNSS. Though the prosecution contends that telephonic intimation was given to the petitioner's brother, no contemporaneous record evidencing such communication has been placed. The purported arrest intimation itself states that the petitioner's family members reside outside the state and could not come to the police station, and that information was allegedly conveyed over phone to the brother. Yet significantly, there is no acknowledgement by the brother nor any material indication material indicating transmission of written intimation to him or to any other relative, friend or person nominated by the petitioner. In matters concerning deprivation of personal liberty, constitutional compliance cannot rest upon subsequent assertions from the bar unsupported by contemporaneous official record. Where a specific allegation of breach of arrest safeguards is raised, the burden necessarily lies upon the arresting agency to demonstrate scrupulous compliance through objective material. 14, 15, 16, 17, 17 the decision of the current bench in Hemchanan Toha Supra and Etu Didiba. Dwatlang Lelento. Mayat Lekhi disu and Koridiba. Then 18, 19, 20, 21, 22, 23, 24, 25, 26, 27. Consequently, the petitioner so and so shall be enlarged on bail in connection with so and so, subject to the following conditions. Yes? 50,000?
All right, madam.
50,000 with 2 local sureties of the like amount to the satisfaction of the learned special judge NDPS. Aizon?
Yes.
Number 2, 3, 4, 5. So you will not leave the jurisdiction of the learned trial court. This is a trial court or investigating officer?
Trial court.
Trial court? Trial court. यहाँ पर एकदम 30 लेके दी दिया 4 huh? All right, allowed. Mr.
Pass
Ali.
on by sure.
Hearing list, item 1.
Miss Mary.
Yes, Your Lordship, my learned friend Jordan was here all along, but then due to time constraints, we
All
have
right, we'll
decided
have it on another date.
next week, Your Lordship.
Yes. As prayed for by Mr. Jordan so-and-so, learned amicus, he's an amicus?
He's an
Learned
amicus.
amicus curie and MS Mary so-and-so, learned APP. The matter stands posted on such and such date.
4th of June.
Or you may actually say, due to paucity of time, the hearing could not take place. Upor teolokor appearance to record koriloba and then repost on such and such date. That's all. I think today is one such day where we all have gathered till such hour, no? So, Miss Mary, how's your daughter now?
Good, good. Thank you, Your Lordship.